Hello and welcome back to yet another session of Lalans IAS. I am Hiranand, Director Lalans IAS. So this has been a very newsy week. We had the parliament in full swing. We saw the real flowering of democracy in India, you can say, if you restrict it to operation of parliament, because there has been allegation that parliament is not functioning, or there were certain issues regarding functioning of parliament because of disruptions, lack of quality debate. But such was not the case, thankfully, in the recent monsoon session, where with the vote of no confidence or the debate on no confidence gave us wonderful issues to discuss. And we felt like that was the end of it. The monsoon session will end with the no confidence motion, but government had other intentions. You can compare it to what you get in Marvel movies. You get the post-credit scenes. So similarly, we got the changes, the proposed bills to change the IPC, CRPC, and Indian Evidence Act. So that was a surprise, but a necessary surprise. So today we will try to have a cursory look on all those things, because all those things are not yet clear. Right now, the position is that those bills has been referred to the standing committee, and they will deliberate on it. Public debate will happen, and then Parliament will do the needful to pass the bills. So, without further ado, let us move on to what we plan for the day. So, the root of all this is the speech of Parliament speech of Prime Minister on 76th Independence Day. This year we are going to celebrate the 77th Independence Day. But on the 76th Independence Day, Prime Minister Modi, on the ramparts of Red Fort, he gave the 5 prans, the Panch Pran, for amrit kal. I'm sure you have memorized these things for means, but it is pertinent to recall these things. Amrit kal is referred to the period of 25 years, starting 22 to 2047. So there he talked about the 5 prans that India should take to make it developed by 2047, or to reach to the status of its predestination, you can say, or its rightful status among the Committee of Nations. So what are the 5 prans? Pran number 1. The first pran is goal of developed India. These are the 5 promises or 5 prans that Prime Minister Modi referred to in his Independence Day speech. The second is directly related to what happened in Parliament. It is to remove all colonial vestiges, to remove all traces of slavery. We have taken various steps. The proposed reforms of the criminal law are one of those steps. The third is take pride in our roots. The fourth is unity. And the fifth is sense of kartabya or duty among citizens. Which part of the Constitution deals with duties of citizens? It is part 4A, dealing with fundamental duties, which were originally not part of the Constitution, but was brought in 1976. Okay, so here let us focus on colonial vestiges. Or colonial legacy. Why do we have a colonial legacy or colonial vestiges? This can be a question that you might encounter in your interview. So, what is why India has a colonial legacy? If you are bluntly asked, then your point blank answer should be: India saw something called transfer of power. In 1947, when India attained independence, it was not through a violent transition of power, but it was a, you can say, relatively peaceful transition of power. There was transfer of power from Britain to India through the act. There was an act passed by British Parliament in this regard, and that transferred the political power from Britain to India. So, since, say, if you compare a country like China, China had a revolution in 1949. It was a revolutionary change in power. So what it resulted in creation of a new identity for them. But India, it was not a new identity. India saw transfer of power. That means we carried forward many legacies, many practices that was practiced in pre-colonial or colonial times. Okay, be it in the field of administration, we saw just the change of name because all the practices remained colonial. In the field of education, okay, similarly in polity, general polity, because the mode of parliamentary democracy that we have inherited is a direct colonial legacy. So these are just a few. Here I have mentioned three, but you can actually explore and find many things. In fact, there is a possibility of an essay on this topic, on the standalone essay on this topic. There you have to explore more fields. But just to give you a hint or a clue, why transfer of power has continued, colonial legacy has continued, it is because India saw not a revolutionary change of power, but a transfer of power. So transfer of power, if it happens, then it will essentially mean that many things will continue. So similarly, in administration or in criminal law can be one part of it. We saw, what did we see? We see the continuation of British laws. In fact, this government has been quite active in repealing archaic laws. They have, I think, more than 1,500 laws they have repealed in the last 8 years. 8 to 9 years. Okay. So, this is an intended goal or pran of this government that it wants to actively get rid of the colonial vestiges or colonial legacy. So, the proposed amendment to IPC are not just a few. In fact, you might get a question: what are the steps taken by government, or what do you think the government has done with regard to getting rid of colonial vestiges? So you should have certain things on your fingertips. Okay. So one thing you can mention, one point is how the Rajpath in Delhi has been renamed as what? As Kartabya Path. Then there is a National War Memorial. That has been merged with Amar Jawan Jyoti in Delhi. Then installation of statue of whom? Statue of Subhash Chandra Bose in place of some British soldier or a person of that lineage or that period. The statue of Subhash Chandra Bose has been installed in India Gate. That is direct, you can say, attempt to indigenize the legacy of freedom movement. Then the Navy, Indian Navy, its naval ensign, it used to be something which had the British flag in it. There was this cross of Britain in the naval ensign, but right now that has been removed. We are having a new ensign. Okay, then renaming of islands in Andaman and Nicobar Island. Like Ross Island is now known as Subhash Chandra Bose Dweep. Then similarly, like in Delhi, there was this famous Dalhousie Road. Now it is called Dara Shikho Road. So these are to name a few, which gives evidence to the fact that government is serious about all this stuff. Okay. So similarly, you can say national education policy. In national education policy, there is emphasis on instruction in mother tongue. So that is again an attempt to get rid of colonial legacy. Then in budget, earlier there used to be, the finance minister used to carry a briefcase while going to deliver the budget in parliament. Right now, what does she carry? She carries a bohi khata. It is called bohi khata. It's like a cloth bag, no? So these are certain, yes, some may consider it trivial, but yeah, there is a concerted effort to get rid of all things which represent India's legacy of slavery. In fact, in this thing, I will share a very beautiful anecdote with you. In China, what happens is that all the colonial buildings that used to be in central Beijing, they are located, or the new city is constructed. Suppose this is the old building that the Britishers or European powers constructed in China. Right now, how they have constructed the new buildings is that if you want to see the new buildings, or if you happen to pass through these new buildings, or you are going through these streets, and these will necessarily be at your back. Means your back will be towards this. So nobody is going to, and they have constructed these new buildings in such humongous and such a beautiful way that your attention will not go towards what existed in colonial times. So this is a clear example where they have obviously not destroyed all those buildings, but they have put it into the back seat. So that is a way of projecting to the world that, look, we have put our past behind and moved on in a better way. So that is a good lesson for India, that India can project its development in a manner that can not only be actually in a, you can say, physical way, you are not only showing it, but also in real practical terms also you are trying to portray that, yeah, we have moved on, we have, obviously we have no grudge for them right now, because no point grudging about some things that happened long time back. But we have learned our lessons and we have become stronger and moved ahead. That is the, you can say, the learning from the legacy that we should always keep in mind. So all those things can, you should keep these things in mind while attempting any answers on such questions in interview. So this is a brief background of how the government's focus has been on removing colonial legacy. So my intention is that you have to be clear what is colonial legacy, and you have to be clear what are the efforts at getting rid of colonial legacy. So now coming specifically to what the changes that has been brought about, it is very naive or very early to actually explore those things, because this will be again going through various debates, discussions, but still having a cursory look at all the changes or all the proposed changes, we can have a couple of ideas. If things stay same till your interview, at least if you are asked what are the new things that has been brought in the changed IPC, or what is now known as Bharatiya Nyaya Sanhita. So what are the changed things? So at least you should have a couple of points. So that is the intention. So IPC, which was originally framed in the year 1860. And remember, who was the person who proposed the IPC? It was none other than Thomas Babington Macaulay. He was the first. He headed the first Law Commission of India, and he proposed IPC, and accordingly 1860 it was enacted, and still it is going on. Now, what is the change name that is supposedly the new name of IPC? It will be known as Bharatiya Nyay Sanhita. Sanhita is code. It's a Sanskrit term. It means collection code. Then this is number one law. Then number two, second law, that is Criminal Procedure Code, originally enacted in 1868. Originally, it was in 1860. Let me just check it once. Sorry. It is originally enacted in the year 1898. Later amended 1973. Right now, this will be known as Bharatiya Nagrik Suraksha Samhita. Similarly, the third act that is supposed to be reviewed and reformed is 1872's India's Evidence Act. And remember, obviously the world has changed like anything. We have electronics, we have IT, we have computers. So all these things need to be incorporated into law. Although certain provisions are there, but we have to consolidate those things and find it in one place. So IAA is supposed to be known as Bharatiya Saksha Bill. I doubt you will be asked directly on these names, but you might be asked on the broad framework. What do you think are the changes, or what changes, what obvious changes has been brought in? So certain important changes which are in news, like section 124 of IPC. Now it is no longer there. What is it related to? It was related to sedition. Right now, sedition is not a crime. Hence, you can, all the provisions relating to sedition is no longer applicable. So that is no longer there. That is an important change. Then section 377 relating to unnatural sex or homosexuality, relating, like, which criminalized homosexuality, that is no longer there. Of course, Navtej Singh Johar, in the famous Navtej Singh Johar case, Supreme Court unconstitutionalized this section, but still right now it is now out of the statute book. 377. Then there is another controversial section, that is 309. You can mention all these things. It's very important, and it is in news. Section 309 of IPC relates to attempt to suicide. Attempt to suicide used to be a crime. Although after the passing of the Mental Health Act, this has like a limited scope of use. But still, it used to. It was in statute book. Now it is no longer there. Then there is this provision for mob violence or hate crime, something like that. So there you can actually go for prosecuting the whole mob. It's not like you have to find one particular person who committed the crime. No, you can prosecute against all those involved and try them under similar circumstance and give them similar punishment. So that is an important change. Then another very interesting change that has been brought in Indian criminal jurisprudence is community service. You can highlight this fact. Community service, especially for defamation, they have brought it down. Community service as a punishment. So, see, I am very sure you should be aware that in Indian prisons or Indian criminal system, we have the problem of under trials. Under trials, 77% of Indian people or Indian criminals, or you can say all the those behind bars are under trials. So if you have such a way of delivering punishment, then it can actually in a way lead to reduction of pressure on criminal system. So that aspect can also be linked to it. Community service as a punishment can reduce the load on criminal system. So these are some ideas that has been explored. Then definition aspect, like definition of terrorism has been explicitly provided. Earlier, what used to be the case, like terrorism used to be interpreted through the UAPA Act, Unlawful Activities Prevention Act. So there again, there are problems of interpretation. So here it has been very clearly defined right now under IPC itself. We don't need to create special laws for special crimes. It is ideally we should not have multiplicity of laws. Like IPC is, what is IPC or what is a Bharatiya Nyaya Samhita? It should cover all nature of crimes, but because it doesn't cover, that's why we have special laws like violence against women. We have Vishakha guidelines used to be there. Then now we have Domestic Violence Act. We have separate act for domestic violence, separate acts for sexual harassment at workplace. So such special laws are there because of the lacunas in original IPC. IPC didn't cover those things. So we are now trying to consolidate these things at one place. So that is a welcome change. So these are certain aspects which you can get, or which is now available in public domain after just giving a cursory look to it. But with time, obviously, you will get further details on the new things that has come up. So till you interpret it, if we get more inputs, then we will obviously look into it. But at least this much idea you should have. Okay, these are the changes that has been brought about, and what is the logic behind it? It is to get rid of the colonial legacy and also to get in tune with the times. Times have changed, so we need to adapt. So these things are very practical, not only like in terms of like getting rid of the history, but also in terms of how you should evolve as a society. Okay. The second idea or second topic that I propose to discuss is disqualification of a lawmaker. Obviously, direct reference is with Rahul Gandhi case. So it was in news when Rahul Gandhi was disqualified and then later he was reinstated. So you should be clear if you are asked what are the ways in which a lawmaker can be disqualified under the Indian Constitution or under Indian laws. Then actually how many types of disqualification is provided in Indian laws? Constitution has two. Okay, Constitution has two, and one is there in the Representation of People's Act. Under the Constitution and under Representation of People's Act 1951. So under the Constitution, what is there? There is Article 102, Clause 1 and Article 191. 191 is for MLAs and 102 is for MPs. Okay, so what are the grounds given? First is office of profit. Somebody holds office of profit. In simple terms, what is office of profit? Office of profit means a legislator. What is his primary role? To legislate and to hold the executive accountable. Now, if he is taking any job, any offer at the behest of the executive, then his role of holding the executive accountable is put to the question. So, to ensure that his integrity remains beyond doubt, we have this idea of office of profit, that any legislator holding office of profit is a ground for disqualification. These things are explored in polity topic further, but just briefly I am referring you here. In course of time we can discuss those things later, but that is the essence of it. Then if he is of unsound mind, then if he is an insolvent, means he has unpaid debt, and then not having Indian citizenship, that can be a ground. That can be a ground. So these are same for MPs as well as MLAs. So these are the provisions under the Constitution. There is another fifth clause. Any other act made by Parliament can propose new disqualification criteria, and those are given here because 1951 Parliament came up with Representation of People's Act, and there are provisions relating to disqualification. Then second way through which an MP or an MLA can be disqualified is there in the 10th schedule of the Constitution, which was brought in 1985 52nd Amendment. So what does it relate to? It relates to defection. When an MP or an MLA defects from his original position or original party, then he is disqualified under the provisions of 10th schedule. So this is the second ground of disqualification. Then where does Rahul Gandhi fit into this scheme? Obviously, he doesn't fit into any of the scheme. His ground is there in Representation of People's Act. So in Representation of People's Act, there is Section 8. Section 8 deals with all the disqualifications. There are other sections also, but Section 8 is what we are, which was in news. It relates to, so Section 8, there is 1A. 1A deals with specific offences like promoting enmity between groups on the ground of identity, religion, race, okay, then bribery, undue influence, all these things are there. Then 2A leads, there are certain specific offences like hoarding, like profiteering, adulteration. Food adulteration is also one of the clause where if an MP or an MLA is found to be doing all those stuff, then he can be disqualified under Representation of People's Act, Section 8(2)(a). The third is what is relevant in our discussion. Section 8, Clause 3(a). It states that if a convicted person for any crime, if a person is convicted by a court of law and if his punishment is for 2 or more years, then what happens? Then the person is immediately disqualified and he remains disqualified for his full term of punishment plus 6 years. Then suppose in 2023, when Rahul Gandhi was convicted of this offense, then 23-24 he had to serve the jail term, provided it was not like the whole thing had not changed, then the condition would have been like this. Okay? 20 till 24 he would have been in jail, then from 24 to 30 he would have been disqualified. So to become eligible for re-election, or to become eligible to come back to the political process, he would have to wait 6 years. So that's why it created such a hue and cry. Okay, so it clearly says that from the date of conviction to 6 years since his release. Okay, from date of conviction to 6 years since release, he will be disqualified. Okay, so this is specifically dealing with what Rahul Gandhi faced. But again, if a higher court stays the conviction and stays the sentence, there is two things to any conviction. Means when somebody is punished, then there is two things. One is his conviction. Well, yes, he has committed the crime. He is a convict. Then second is the sentence. Had the higher court only suspended his sentence, then this clause would still have remained. But here, his conviction and sentence both has been stayed. That's why his process has been, he has come back to the parliament. In fact, there was another important, or you can say controversial clause to the section 8. There was section 8, clause 4. Actually, what happened was that earlier it was declared null and void in Lily Thomas case in 2013. So before that, this provision provided protection for convicted MPs and MLAs. How? When at the time of conviction, they used to get 3 months of suspension of the conviction, or their process used to be held for 3 months, so that in that interim they could appeal to the higher court. So obviously within 3 months you can appeal and you can continue to stay, because court cases linger for long. So that 3 months was a kind of buffer given to them. That way no convicted person were disqualified. So after the annulment of this clause, things has become more fairer. Now they have to be really careful. Otherwise, they will lose membership, as seen in Rahul Gandhi's case. Okay, so then there are certain controversial, you can say debatable issues raised by Supreme Court in the last year regarding disqualification. So there was in 2022, there was this issue that whether providing of false information relating to your educational qualification amounts to corrupt practices under Representation of People's Act. Means under corrupt practices, if you are like you are supposed to give your assets and liabilities, there if you are providing false information about your educational status, then is it a corrupt practice? And surprisingly, Supreme Court said that no, it is not a corrupt practice. Because what the logic given by Supreme Court was that Indian voters do not vote on educational qualification. There is a larger context to things which should not pick that particular aspect only. There was a larger thing, larger context at play, but still that is something that became quite a controversy in February this year. Then another thing related to election and disqualification is the freebies. What is freebie? Freebie, you know, something given where you don't have to pay the cost. So this is again a matter right now. It is in Supreme Court, but there was this case, SS Balaji case 2013, which says that promises of freebies cannot be considered as a corrupt practice under electoral under Representation of People's Act. But again, it is up to reconsideration. And then 2017 also we had an important Supreme Court judgment in this matter relating to disqualification, where there was Supreme Court said that appealing to any religion, race, caste or language or such matter amounts to corrupt practices under representation of people side. Because again, they were referring to previous cases like S.R. Bomai, where it was clearly defined that secularism being a basic structure, it means that state will not digress, or contestants will not invade those areas to garner votes. But it is a very debatable issue because, see, again, this was pointed by Justice Chandrasur itself in the 2017 judgment. He pointed it out as a dissenting note. He said that, okay, we can accept that we should not appeal to religion for votes, but if somebody is suffering because of that identity, then why cannot be the election issue? Because that way democracy will be more a substantial thing. Now, if you are excluding all those things, then you are merely putting democracy as an abstraction. So that was the observation of the serving Chief Justice of India, that we have to, be very careful in these things. Like, we cannot put things in black and white. There has to be a nuance to these arguments. So these things always pop up, and this creates opportunity for opinionated question and interview, because you might be asked, what is your opinion regarding this and that? There, if you are just plainly speaking in black and white terms, then actually it shows a lack of depth. It shows that you have not explored these things further, because there is debate, and debate is the beauty of democracy. So you need to explore those things. Okay, so till we come again with another important topic, another interesting topic. Thank you from my side. Take care.